Thank you.
Hi there. Excuse me.
Go ahead.
My name is Lisa Baker-Jones, and I'm the immediate past chair of the Northern California chapter of the American Immigration Lawyers Association, otherwise known as AILA. And I wanted to just make 3 brief points. Ignacio gave a good summary, particularly in terms of where we are in. There are a lot of crossover areas of agreement in terms of what this bill can accomplish, but there are some areas that we feel need to be tightened up, perhaps, before we're able to remove our opposition. One of the first things I wanted to talk about was the construction. There are some legal terms of art that are used in several places throughout the amendment that need to, I think, be changed to sort of reflect, what the correct terminology is. So, for example, the use of the word visa. Right now, it says that if a person overstays their visa, then they're considered to be in an unlawful status. But in actuality, that's incorrect. What needs to happen is a minor change. We would suggest that a non-immigrant visa status be changed to the period of lawful admission, which would be correct from an immigration law point of view. And for example, if someone were to come into the U.S. on a visitor visas are usually granted in 10-year increments, and so someone can enter on a visa for 10 years and overstay and be here unlawfully, but still be here under a valid visa. So the correct terminology would be the period of lawful admission. And then the other issue is with regard to the term a lawful status. And the reason this is coming up right now is because DACA and DAPA do not confer a lawful status on the applicant. The USCIS has said so. I believe, submitted a letter. If you guys need references or anything, we're happy to provide them. But it's not a lawful status, unfortunately. So, I think we need to do some maybe playing around with some of the words there. And I know that Assembly Member Gonzalez and her staff have been really amenable to working with us, and we would like to continue that working relationship. The second point I wanted to make is with regard to the date of enactment. Right now, the way that it's set up, it's unlawful for an attorney to accept fees before the USCIS accepts those applications for DACA or DAPA. And what it does is takes away any sort of preparation time that an attorney can use to prepare an applicant. Both DACA and DAPA, the applicant needs to show at least 5 years of physical presence in the United States, and it can be hard to prove. I mean, we're all online right now, but not all of our clients are. And so being able to, come up with that kind of documentation is actually like sort of the crux of the position of their eligibility for the program. So we would, like to work with Assemblymember Gonzalez's office again and be able to sort of firm that up so that perhaps it could, we could change that to be, upon the announcement of when the program will be in place. I mean, we understand it's in litigation right now and there's nothing that can be done. But we would like to work with you all on that language. And then the third point I wanted to make, I think, so this is a national program, assuming that the injunction gets lifted, which we're not sure it will. But, we don't want to disadvantage California immigrants by not having reputable immigration counsel assist them in the process. There are a lot of nonprofit organizations that are out there right now that are helping for free. We commend those kinds of services. Right now, the only people that are permitted to appear in front of immigration proceedings are attorneys from any state in the U.S., and then also BIA accredited reps, Board of Immigration accredited representatives. And so they're certified individuals. And so the number of good attorneys, the number of BIA accredited reps is actually kind of small compared to the population that could be helped. So while there could be like a chilling effect, maybe, which Ignacio had mentioned previously, on the attorneys that would be willing to be able to assist, but really it's not even so much about the chilling effect on the attorneys as it is on the people who we're trying to help. And having access to good counsel is critical in these cases. Immigration law is really complicated. Something that somebody did 20 years ago and forgot all about can really come back and haunt them in later times. And having somebody who knows the law and who is able to really, go through the process and their entire immigration history, it's invaluable.
Thanks very much. Very briefly here, did you have any comments?
I'm Mary Waltermeyer. I'm here on my own behalf. I'm an attorney in private practice. I'm a certified specialist. I've worked for a decade in the nonprofit sector with immigrants. I'm now working at a private law firm. My concern I wanted to address is page 4, line 30 through 34, subsection C, the expanded provisional waivers. Those are not subject to the litigation right now. Those will be going forward. Provisional waivers take months to prepare a high-quality waiver, and we know that those are coming. There's no lawsuit against them. We know what all the provisions are. It's simply expanding the group of people that will be eligible to apply for these waivers. So the concern is attorneys are essentially prevented from assisting clients with those right now. We have to wait until they can be filed before we can assist people with it, so we lose.
So you'd like to have an exception for this area so that that you can proceed moving forward with these expanded preparation of the expanded provisional waivers?
Yes, so clients could hire us to do that work.
All right, some information for the Assembly member, and we'll let you respond to those as perhaps in your close questions. Senator Monning.
Thank you, Madam Chair. I want to thank the Assembly member for bringing this forward, and I think there's obviously a shared interest in protecting immigrants from exploitation. I mean, that's a starting point for everybody here. A couple of my concerns, and I'll direct some of these questions to the author. I'm aware in the communities I represent historically, some of the worst actors are notarios and consultarios and people who hold themselves out as attorneys and aren't attorneys. None of this bill addresses their conduct, or does it?
No, these prohibitions are on those folks as well.
As well?
Yes, it extends the prohibitions.
Not limited to attorneys?
No, absolutely not.
And then who has the authority to enforce violations against notarios and consultarios?
Unfortunately, I think as Senator Wachowski could probably expand on, I think this was a note of concern with the bar versus an older leadership of the bar and the newer leadership of the bar. It's still being worked out whether the state bar, what, if any, role they have in the unlawful practice of law. Or the unregulated practice of law. However, it is still under the authority, I think we heard from the DA's, LA District Attorney's Office, the City Attorney's offices, is still subject to criminal litigation until or unless we can work out the role of the state bar in that. I think that's always going to not satisfy our desire to come down hard on these folks.
Thank you. And then with respect to the concerns that have been raised by the immigration attorneys, as somebody who practiced immigration law, and as you know, my daughter's an immigration lawyer who does mostly deportation defense and political asylum, but the nuancing of this, as has been pointed out by some of the witnesses, the ability to help a client collect documentation they need, potentially expunging a misdemeanor conviction or some other infraction, and the time that it takes to assemble materials. Could you respond? A couple of examples were given. The one about being able to work currently on requests for expanded provisional waivers.
And I want to be clear, the bill only doesn't allow the acceptance of advance fees for that. So the work can continue to be done, and then, but you can't solicit for a program that you can't accept, that you can't file for now, basically. And if we need to work on, that was the first time that specific piece had been brought to me. I'm more than happy to go back and look at where that is now. Obviously, when we introduced the bill, it had yet to be enforced. Our main concern is this, and I'll continue to work on AILA on some of the other things, but our main concern is this. DACA, expanded DACA and DAPA may never exist. And it was the same concern we had about immigration reform. Unfortunately, it may never exist. And what is happening here, and I have 3 or 4 examples of AILA attorneys who on their website, one of them suggests in an advertisement that you can get a consultation, and they call it for hopes and dreams. And for $150, you can start your paperwork for DACA, expanded DACA, and DAPA. That's what we're trying to prevent, because we think it is patently unfair that immigrants who work hard and want nothing more than to receive some kind of normalized status are giving attorneys money for the preparation materials for something that may never be of value. The post-conviction relief is a separate value, and so it states in the bill anything that has an independent value, like in the specifically post-conviction relief, stopping deportation, those can move forward. But we have a number of organizations, including Congressman Gutierrez, who has put out on his website a really handy list of the things you need to go do as an individual to prepare in case DACA or DAPA comes to fruition. Things that you can go do, documents that you will need. What we don't want is people to be charged for this activity, pay good money, and then never be able to utilize the function for what they've been promised. And we have. So I'm willing to work specifically on the request for expanded provisional waivers. Again, it was meant only to not get advanced fees for, until, and it says, until the effective date of new guidelines and regulations. So as soon as there is an effective date for those provisional waivers, it doesn't matter if it's in the law, then you can receive money for it. So obviously these things are changing quickly. My hope is that we don't need this bill because, the executive order is in place, but that's not the case right now.
It's not the case right now. And the example you read of that ad, I don't hear anything in the opposition position that would support the promise made in that advertisement. So I think the challenge is to have the precision that allows legitimate services that you, in your own words, don't disagree with, that can be defined with some precision so that it doesn't serve as a restraint against people who are in good faith working to help clients move forward. There was also concern raised about some of the use of language in non-immigrant visa versus period of lawful admission. Do you have any objection to fine-tuning that?
No, and some of, although I appreciate what is being said here today, the majority of the discussion that I've had previous to today with AILA had to do with the document preparation for DAPA and DACA, and that is what I wasn't willing to move on. On these other specific tweaks in language, absolutely, let's work on it. I've said, and it says in the bill, and we already added anything of independent value and added in post-conviction relief and deportations, and we're willing to write, at the suggestion of this committee's consultant, a letter to the file to ensure, to lay out what those things are. We don't want to catch up good attorneys. We just also don't want otherwise good attorneys who think, and again, I have a lot of advertisements say, get first in line, prepare your documents now. That's fine. We just don't want you to take advance fees for that.
You mentioned to me the possibility of a letter to the file. That's helpful maybe if somebody's in court trying to defend themselves and show the intent of the law. But if time permits, I would rather see anything that might be specified in a letter to the file referenced explicitly in the bill. Where does the bill go from here?
It goes to Senate appropriations, so there will be time to address that, and I hope, and I've heard you commit that you will continue to do that, because from what I heard, and I understand that the discussions have shifted, which is, well, no, from some of the conceptual now, we're talking about some of the specifics here, and that's a good thing, the notion, what's a visa? I think that can be worked out. I don't think you intended to preclude anything. Date of enactment, tweaking that. I was concerned here, we have some good lawyers who do this work, and we don't want to lose them because, as you say, immigration law can be very complicated. On the other hand, we want to protect against abuse, and so I think we're all there on the balancing. I would just like to ask if I could. We don't. You mentioned that once we have an effective date or upon pronouncement, then fees could be charged. Did I understand you to say that with respect to the expanded provisional waivers of unlawful presence, that is actually moving forward, or that you're already doing the work, because that is not subject to the litigation right now, and there will be no enjoining of that effort? That is actually either happening or to happen within days or weeks? What's the status of that?
I can't give you the precise time frame. The Obama administration has announced that this is what they're going to do. They're expanding the number of people who can do this, and they're going to do it in a regulation. That's fairly far along in the process. Precisely when that will happen, I don't know. I doubt there'll be a notice and comment period. I think it'll go into effect as an interim regulation because there's no substantive change in any of the requirements.
So what is the legal, if it's an interim regulation, that means that people can start actually, so is there any language here that will allow at that point when it becomes an interim regulation?
It's the ability to do the work in advance. I mean, what does advance fees mean? The standard practice with immigration attorneys who are working with the folks this bill is directed at, they're progress payments. You have one payment to start work, you have another payment when you complete a certain portion of it, you have another payment later. The bill as written would apparently not allow us to charge any sort of a retainer payment, not put any money in trust. We're allowed to do the work, but we're not allowed to charge anything for it until it can actually be filed. Now, if something's speculative, like DACA and DAPA, I'm sorry.
Yeah, no, I understand. So is that your intent, to allow them to do the work without getting any kind of periodic payment for it?
If the action doesn't exist now, if there is no relief possible for a client, yes, if they would like to do the work.
So is there no relief available right now?
With DACA and DAPA, it is speculative. It's tied up in litigation.
Okay.
I don't quibble that charging for that now is something that could be reasonably found unethical.
Okay, so, but what you're saying is,
Once it's allowed to go forward, we want to be able to do the work in advance of the date you can file the application, rather than not being able to do anything until the date you can file.
all right, so
And that's not,
Assemblywoman.
I'm sorry, that's not what it says. It says the issuance and effective date of new guidelines and regulations for these provisional waivers. So it's the actual issuance of the guidelines, not the date of acceptance.
All right, so does that clarify? Yes.
Just for clarification, I think the Assemblymember is correct in what she just read off. I think on the DAPA and DACA, it does say when they begin accepting those requests. So I think the language in DAPA and DACA provisions are a little bit different than the provisional waiver. Just
Right.
clarification.
All right, I don't think we're far apart here, so could we have you continue working on that and see if we can't get some clarification there? Because if this is going to happen, I agree, we want to get people in the queue, if you will, but if this is all speculative, then it does appear to have some real kind of fraud aspects and inappropriate aspects to it. So we had Senator Anderson and then Senator Morlock. Anyone else wish to? Senator Leno, thereafter Senator Anderson.
I support legal immigration, but whether it's an employer who fails to pay his workers or an attorney that takes a deposit for mysterious work, exploitation is exploitation. And the fact of the matter is, in San Diego, you can open up any paper and see those ads. No one is doing anything about it, and those people are being exploited. Plain and simple. We should be offended by those attorneys as we are any employer who fails to pay workers. And yet we're having a difficulty with this issue. It's clear as a bell to me. I'm prepared to move this bill when the chair is ready.
Well, excuse me, Senator, I think we're having, we all want to accomplish the same goal. It doesn't just happen overnight, and I know the Assemblywoman's been working hard on this, and I know that many of the attorneys who are here today are here on their own dime because they care about their clients. So I don't want to operate on the assumption that everybody involved in this is excuse me, I'll give you your moment. So I don't want to be operating on the basis that all lawyers are being lumped into the bad guys. There are a lot of really good lawyers out there who care about their clients, and what we're trying to do now is work this out so that we protect the clients and the attorneys who are working towards for the benefit of their clients, and we take care of those bad guys out there. They're in every profession, in every walk of life, and we want to make sure that we do the right thing for the clients and make sure that there are good attorneys there who can do that work for them. This is a complicated area of law, and we need the right people and the good people to be doing that work. So with that, Senator?
Madam Chair, I didn't say all were. I said that the ones that were advertising for it were, and I'm sorry, these people are preying on the weak, and that's wrong. And I'd love to co-author this bill, and I'm happy to move it.
All right, very good. Thank you. I don't think anyone disagrees with that. When the time comes, when we're done with discussion, we will accept that motion. Senator Morlock.
Thank you, Madam Chair. I'm not a lawyer, so, but I am a certified public accountant and was a partner in a firm, so I certainly appreciate new clients coming in, and there's always that concern, will I be compensated? Will I, after I do my work, will I send out my bill and have payments? And so I'm being told this bill would provide that it is unlawful for an attorney to demand or accept the advance payment of any funds for Immigration Reform Act services. And so I'm kind of mystified. Is there a reason why a retainer is required, or what kind of payment history or collection history have you had where you weren't paid after providing services that makes a retainer very critical in your profession?
I think briefly what prior witness described is that one of the common practices is accepting a retainer, putting it in trust, and then there are progress payments that are drawn down. Getting paid for services that are never provided is something that's prohibited under current law. So I think that practice is what the concern is with this bill, for those attorneys that use that model of payment.
You could be disbarred if you were to take money out of the trust, taking payments from the retainer if you weren't providing
Yes.
services or inappropriate services. So what are we trying to fix? If the retainer is only $150, and I apologize, I haven't seen the ads. I mean, that's the what, half hour of your time?
I charge a lot less but with all the work I do. I don't know if we want to get into what the charges are, but I think maybe the proponents can speak to the intent of the bill. But the concern is on the advance payment is just for those attorneys in those situations that use that model of the retainer and then drawing down progress. Just making that's where the concern is, that they may not be able to even accept that retainer up front and then do the drawdowns.
Gonzalez, has this been done for attorneys in any other area of law, where you say you cannot take a retainer? Is this?
I
don't
believe
know.
home foreclosures was a big issue in this body a few years ago. And the same, what you have is you have such a broad aspect of attorneys. And I don't want to say that every attorney who advertised, because I have a number, some of whom I know, I think they were excited about the prospect of DACA and DAPA. And so people come in, you either have, sometimes they say, you know, for this amount of money, we'll do your paperwork, so you pay that amount of money. But they were accepting fees and continue to accept fees for something that does not exist. Now, are they doing work at billable hours? Yeah, they could probably justify that they were doing billable hours, but it was for an unnecessary function because it just doesn't exist, right? And so what we want to get away from is attorneys and even more important, consultants and notarios saying, come in, get first in line. There's no line to get in. And we passed this law previously for Immigration Reform Act services under Congress because we had the same fear, and that fear was realized after 2013 because it never came about, and everybody said, but it's going to come, and we got to get prepared, and we've got to get people ready. But it didn't happen, and the people who had given up their money in advance had nothing to show for it. And $150 in my community actually is a lot of money. You know, that can be, quite frankly, a month's worth of groceries. So to give up $150 even at a consultation for something that they'll never get a value from is what we're trying to prevent here with this bill. And so I think, unfortunately, people got very excited, and then the federal judge acted, and now we're all left wondering, and I think we could take a poll of this committee and come up with different answers of whether or not this will ever exist.
Well, part of the problem, of course, is the Congress has failed to act. So rather than blame the lawyers, let's perhaps point the finger where it belongs, and that is that there has been no action in Congress, and there has been action on the federal side, and there's been injunction against that, and so here we are in limbo, and that's part of the problem. If there were some direction given, these lawyers would come out and they would do their work, and I would also indicate to you that it is a very common practice in the practice of law to take a retainer for services, to put in a trust account that you cannot draw on until those services are rendered. That's a model that is used in the practice of law and has been for years. And so long as the State Bar does its job and punishes those who take money that they haven't earned, then we're in good shape. That's not the issue here. What the issue is that there's work being done in many instances by people in good faith. As you say, we all hoped and expected and are perhaps still naive enough to hope and expect that there will be some movement on this issue. There should be, but there hasn't been, and hence we are here today. So I hope that explains it. Senator Leno.
Thank you, Madam Chair. Assemblywoman Gonzalez, you've articulated the need for the bill very well. And Madam Chair, I think you have negotiated the conversation here well. I was just curious more a little bit on process. Had you stated, I'm speaking to the attorneys in opposition, your concerns with the bill as you're doing today in the Policy Committee, Judiciary Committee on the Assembly side? Was your presentation much different there? The reason I'm asking is the bill's in the second house now, and I just want to make sure that as we continue to move this forward, it's almost at the end of the line that the concerns are addressed, because I agree with you. I think we're very close, but if you could respond, that'd be helpful.
Madam Chair, if I may, and I'll tread very carefully here. The bill was heard in Assembly Judiciary Committee. I'll speak for myself. At that time, the ALA members spoke for themselves. I was not at that point representing them. So, I mean, I can just speak for myself. So I don't know what discussions took place beforehand. I don't know that there were a lot of discussions beforehand. Since that time, I think over the last week or two, we actually there was a letter that was distributed, I believe, last week, or perhaps beginning of this week. I'm losing track of time. Maybe earlier than that, to both, I think, the committee and the author, and there have been, a number of discussions, including mock-ups of potential language, I think, kind of views from both sides to generate discussion. Part of the challenge, and let me apologize ahead of time for saying this, because I'm trying to tread very carefully. The bill, it was always intended to try to work something out before the Senate Judiciary Committee hearing. The bill was set for hearing, I believe, last Thursday. Again, we have no qualms with that, but typically there's a longer lag period of time between when it's in the file and when there's a hearing. We have no problems with that. We expedited our process from Thursday until today, and had a number of conversations with the author's office. So that being said, I think there's good faith on both sides to try to work this out. And some of the issues were addressed in the letter that was distributed to everyone, every committee member, and also to the committee and to the author. And we had a conversation yesterday. A couple of the issues may not have come up. We may not have gotten to them, but in our mock-up, I think a lot of the issues and a lot of issues that we didn't raise today were in the mock-up of proposed amendments, if that helps.
And just lastly, Assemblywoman, can you speak to anything that ALA's put forward that you don't believe you can get to?
I think we have to be very careful in expanding the number of, in detailing the number of services that attorneys can conduct for pay before this. It was clear because of their testimony in Assembly Judiciary is why we made the changes to specify that anything with independent value. I mean, the problem is, as we detail what may or may not have independent value, we're creating loopholes for the consultants and notarios that can look at that and create justification for anything they do. But we did add things that have independent value, including post-conviction relief, which is a huge issue under this bill and everything else. We know regular deportation and the ability to stay in the United States. I am hesitant to continue to add to that list of FOIA requests, and there was a litany of things put forward. So we did try to address that, and then through the consultant suggested that we would clarify more in a letter to the Journal if that was necessary. They brought up the issue at one point. This has been a litany of issues that existing DACA, this would prohibit attorneys from applying for existing DACA. That it's not in the bill, and so I don't want to add that. I don't want to mess up our bill with things. Why would that be a situation? They brought up attorney-client privilege. It has nothing to do with attorney-client privilege. So there have been a number of issues that have been brought up that bear no relation to this bill that I don't want to just keep piling things on. I want it to be clear. You just can't take money for DACA and DAPA services that don't exist. And we want to keep it as clean and neat of a bill as possible in that sense. As far as some linguistic changes with visa and the word choice that's being used, absolutely, let's change it. We're getting to specifics now that there's no problem with that. I'm still comfortable, and if this committee is not comfortable, I'd like to know that with, not allowing payment for services until the guidelines are put forward, not allowing payment for the services until that service exists. We just saw what could happen. I don't think any of us in November of last year thought, oh, there will be a judge's order stopping this from happening. That's kind of the problem. So attorneys, some in good faith, some not, went forward, started taking money from folks, and now we know that this is not going to happen anytime soon. It may never happen. So we do want to be careful and not open the doors for another speculative date until we know that this cannot be enjoined in court, that the injunctive, that the injunction is gone, and that they're actually accepting applications for what we all had hoped, the hopes and dreams, as an AILA attorney would say, for these immigrants. So I'll continue to work on kind of the details on language, absolutely, but it kind of, the AILA arguments in Senate, in Assembly Judiciary started here, and it started about document preparation for DACA and DAPA. And we're still hearing a little about that here, right? We're worried that California residents will be, or California folks will be in a bad position because once it opens up, if it ever opens up, they won't be ready with their documents. Well, there are a number of ways to address that. I'm not going to get into that argument. If they want to do that, then my bill's done, right? So does that answer kind of where we are, how we got here? And obviously we have an urgency matter. This is happening right now. Every day that we're not acting, more and more immigrants are paying people for a service that is highly speculative. And so that's what we want to stop, and why it's so important to continue to move it along.
I think with the narrowness of the specific to DACA and DAPA, that other outstanding issues should get resolved, but I'm confident that you'll get there.
And I would like to say, with that in mind, as I understand that your concern under the expanded provisional waivers of unlawful presence, those are not part of DACA and DAPA. They aren't. So would you be amenable to a discussion? What you're saying is that it is going to happen, because that's not under any injunctive program. Are you satisfied that Assembly Member, are you satisfied that that is the case?
I don't know. I don't know. This is the first I've heard of it, so I can't go check that out. I mean,
So would you try?
trust but verify.
Exactly.
But
So
it does on that. It doesn't talk about the acceptance of an application in that. It talks about the issuance of
new guidelines.
an effective date of new guidelines and regulations for those provisional waivers. I would think it's good practice. I don't know exactly what's in those waivers, but I think it would be in good practice to wait until those guidelines are issued before we're doing work on exactly what's necessary. But can I please go check before I? Sure. I would like to believe and trust, of course, what.
Well, I get. What I'd like to do is ask you to respond. You're kind of shaking your head that actually you would like or believe that it's helpful or appropriate to do preparation in advance of new guidelines and regs. Is that what you're suggesting?
Yes, because we know what's going to be in there. It is simply expanding it to a new group of people. It changes no substantive law. Putting together a good waiver takes between 3 months and a year. They're fairly far along in the process. It's not tied up in litigation. I would like to go forward now, getting it ready.
So what I'd like to, 3 months to a year, that can be a long time, but would you be willing to just have that conversation and see, we don't want to undermine the intent of the law, no question, we don't want people being taken advantage of. On the other hand, there's some lawyers who are actually doing good work and are not going to be, well, we don't think are going to be subject to stop and start and stop and stop. But if you would satisfy yourself that that is the case, great. If you're concerned, I don't want to see this bill die because of that, for the reasons you've articulated. There are a lot of people out there who are getting railroaded and deceived, and we don't want that either. So if you would commit to just having that conversation in good faith.
Absolutely. I just, obviously want to see what is exactly under the.
Fair enough. All right. So any further questions? We have a motion. Briefly, I know you've been addressing these issues, briefly close, and we'll take the roll.
I respectfully ask for an aye vote.
Well said. All right, Madam Secretary. This is due pass to Senate Appropriations, where further discussions will be held. Please call the roll.
Jackson. Aye. Jackson, aye. Morlock. Morlock, aye. Anderson. Aye. Anderson, aye. Hertzberg. Aye. Hertzberg, aye. Leno. Aye. Leno, aye. Monning. Wachowski. Aye. Wachowski, aye. 6.
All right, that bill has 6 votes. Thank you very much, Assembly Member, and we'll hold the roll open. Yes, Senator Leno.
Move the consent calendar.
Excellent idea. All right, we have a consent calendar comprised of 3 items. 2 Wachowski matters and a Morell matter. Please call the roll.
Matters off the consent, please.
Jackson.
Aye.
Jackson, aye. Morlock. Aye. Morlock, aye. Anderson. Aye. Anderson, aye. Hertzberg. Aye. Hertzberg, aye. Leno. Aye. Leno, aye. Monning. Wachowski. Aye. Wachowski, aye. 6-0.
6-0. That consent calendar is on call.